This is Colin O'Keefe here once again for LXBN TV. With Valentine's Day here, romance is in the air. But is it in the air at your workplace? Joining me now to share some guidance on how employers can handle office romance is attorney Tiffani McDonough. She is based in Philadelphia with Obermayer, and she is author on the firm's excellent blog, HR Legalist. Tiffani, first, what proactive measures can employers take to protect themselves when it comes to office romance?
Well, Colin, office romances are extremely prevalent and, unsurprisingly, extremely difficult to regulate. While an employer would be hard-pressed to completely prohibit office romances, employers can take proactive measures to reduce potential liability in any type of subsequent sexual harassment claim or retaliation claim. So first and foremost, employers should have a sexual harassment policy, and that policy should be distributed to all employees. Employees and supervisors should be trained on the policy, and it should also outline a formal complaint reporting procedure. Second, employers might want to consider a formal office romance policy. And in those policies, basically, if an employer wants to place a limitation on the type of office relationship, for instance, if an employer wants to completely prohibit relationships between subordinates and supervisors, that would be outlined in the office romance policy. The office romance policy could also require the disclosure of the relationship to human resources. And then finally, that policy could outline acceptable conduct in the workplace. So for example, if the employer wants to prohibit any type of public displays of affection or suggestive talk, they would put that in a policy. Now, a little more controversial, but certainly another step an employer could take to reduce liability would be a love contract. And a love contract is essentially an agreement between the two people in the relationship, disclosing the relationship to the employer and disclosing it as consensual. Now, if you're going to do this, you should do it at the outset of the relationship or when it's reported to the company. Love contracts, they haven't really been tested in the courts. There's very little litigation over them. So their usefulness as a tool to be a potential defense in a claim that might later arise is still kind of an open question. But at least, if you have a retaliation or sexual harassment suit that comes up after the relationship ends, you could use this as a tool to show that the relationship was in fact consensual.
I see. So speaking of those claims which may later arise, what are the ways that employers oftentimes open themselves up to potential liability? What are the claims that you most frequently see?
Well, the most common claim that you'll see is sexual harassment. So that can arise out of if a relationship is between a subordinate and a supervisor or between two coworkers of equal rank. Employers are also exposed to retaliation claims, particularly if the relationship was between the subordinate and the supervisor, and the subordinate claims that after the relationship ended, the terms and conditions of their employment changed. Interestingly, third-party employees can bring claims of sexual harassment under Title VII, even though they're not involved in the relationship. So a lot of times when you see these type of claims, it's when you have a relationship between a subordinate and a supervisor, and the supervisor has been in relationships previously with other subordinates. So what the other employees claim that are not in relationships with the supervisor is that it's this idea of widespread sexual favoritism, so that they're professionally disadvantaged if they're not actually engaging in a romantic relationship with the supervisor. Now, there's a distinction. The courts and the EEOC have agreed that paramour favoritism is actually not actionable. And paramour favoritism is when you have a subordinate and a supervisor in a relationship, and the supervisor is perceived to give preferential treatment to the subordinate on isolated occasions, and only that one particular person. And the courts in the EEOC say that that's actually not actionable under Title VII because it really doesn't depend on gender. Rather, anyone that's not the paramour is disadvantaged, whether you're male or female. So it's an interesting distinction to note between this idea of third-party employee claims of hostile environment based on widespread sexual favoritism and this idea of claims that are not actionable based on single preferential treatment.
I see. There are a lot of ways that employers can open themselves up to potential harm, but of course there are a lot of proactive things they can do to protect themselves as well. Once again, that was attorney Tiffani McDonough. She's based in Philadelphia. She is an attorney with Obermayer, and you can be sure to see more of her insight on this subject and others in the labor and employment space at hrlegalist.com. And of course, if you're not already watching us here on LXBN, be sure to visit LXBN.com. You can find more of these video interviews and curated commentary from the Lex Blog Network. With more than 8,000 authors, it is the largest legal blog network in the world. Thank you for joining me today, Tiffani.
Great, thank you.